Now we are going to study the theory of the criminal type. Let's begin by examining the terminology from the general to the particular. Let's start with the differentiation between criminal type and typicality. And what are its foundations? What is TP? What is typicality? The type in the legal description of the objective and subjective elements of the conduct that is considered criminally relevant. Typicality, on the other hand, is the quality, it is the characteristic of a behavior that causes typicality with the type. A first attribution judgment is important, a judgment made by the judge, in which it is established that the conduct carried out complies or does not comply with the legal determination. So, what is it that we should not confuse the description itself, which is the criminal type, with its attribution, which is typicality? Let's look at the following diagram. What we just saw is typicality type terminology. And now we are going to see the functions and how the criminal types are divided. The criminal type fulfills a guarantee function. It also fulfills a dogmatic function. And if we want to divide it, we have to distinguish between an objective type and a subjective type. Let's leave the scheme. What is the content and functions of the criminal type? At least the core or governing verb must be clearly described. This corresponds to the principle of typicality as a manifestation of the principle of legality contained in Article 19, number 3, paragraph 8 of the Political Constitution of the Republic. What does this mean? The behavior described has external and internal objective elements of a subjective nature. Therefore, the judge must make an objective attribution judgment and another subjective attribution judgment. The criminal type fulfills two functions which are essential in a state of law. What are these functions? Firstly, a guarantee function that is of a criminal political nature and a dogmatic function. The function of guarantee prevents the abuse of criminal law against the citizen and limits the action of the state authority in such a way that it must adjust its determinations to the limits established by the legal system itself through the principle of legality. On the other hand, the dogmatic function, it consists of attributing, or rather describing, the elements whose ignorance excludes pain. What does he mean? This means that the type works as a driving shaft. For what? To determine whether the active subject can be accused of his commission, as well as to have firm basis in order to determine the existence of an error, whether defeatable or invincible. As we will see later, the invincible type error. It excludes pain, and with it, typicality, injustice, and finally, crime. Let's now look at the elements of the type. Let's look at the following diagram. The objective type contains descriptive elements and normative elements. There are several ways to study the elements of criminal types, but we can say that according to the majority, we find a conduct, objects, the material object, the legal object, the active subject, the passive subject and circumstance of time, place, and mode, and finally, between the result and the conduct, there has to be an imputation. Objective, let's leave the scheme aside. So let's look at the elements of JDP. What are descriptive elements? Descriptive elements are usually conceived as concepts that we can grasp with a simple operation of knowledge. For example, woman, man, house, animal, day, night, etc. For their part, normative elements require value judgments. For what? To be captured, for example, without the right, Article 141 of the Punishable Penal Code, Article 432, good manners, Article 373, artistic value, Article 158, etc. These value judgments may be legal or they may also be cultural. However, the descriptive elements also require some assessment, but of lesser intensity. Since there are no automatic captures, the legislator can describe elements that must be present and others that must not be present to configure abnormal behavior, that is, non-accepted behavior. In general, the type usually describes positive elements. What does this mean? That must be present to complete the type, such as appropriating, killing, injuring, mistreating work, uttering certain words, etc. But the law also contemplates elements that are called negative, which must be absent, for example, without the right of Article 141 of the Penal Code, without the will of its owner, Article 432 of the same code, without the consent of the woman, Article 342, without her will, Article 146, etc. What are generic elements? They are the common elements of every crime, or at least a certain category, such as intent in intentional crimes or fault or recklessness in quasi-crimes. Specific elements are those specific to a certain type of crime, for example, motive of profit in crimes of robbery and theft. Objective elements point to the material characteristics of external behavior, which is why it is called objective type. They may describe only an external activity in the case of an activity-only offense, or an activity followed by an external result, and a causal link in the case of an action-result offense. Material, subjective elements, the so-called subjective type, refer to the subjective internal characteristics of behavior. As a general rule, there must be pain, since most types are intentional. Exceptionally, crimes are committed with guilt, the so-called quasi-crimes or culpable crimes. Some crimes also require special subjective elements that go beyond pain, the so-called motives, for example, the aforementioned motive of profit in the theft of Article 432. With this, we move on to the next capsule.